Hi again. This is the third and last video for this week. And in this video, I thought that I will summarize for you briefly, on the one hand, the procedures, the rules of procedure in general for individual applications. And then on the other hand, I thought that I will explain in more details a very particular kind of procedure at the European Court of Human Rights, namely the pilot procedure and the pilot judgment. Now, what happens, starting up with the general rules of procedures, what happens when an application hits the court? You see, even on the slides that, one of the slides, that there is a huge overload, a backlog of cases at the European Court of Human Rights. So obviously there is an institutional interest to get rid of all the applications that are not focused on serious violation of human rights or that do not comply with certain procedural rules or requirements of the court. And those criteria are the admissibility criteria. So those are the preconditions that one must keep in mind when he or she would like to turn to the European Court of Human Rights. Because if one of that admissibility criteria is not met, then the application is thrown out to the garbage by the court. So it's rejected immediately, and the case won't be decided upon in the merits. Now, when it comes to admissibility decision and admissibility criteria, you have the readings. Once again, I expect you to read only 3 points with regard to admissibility criteria: exhaustion of domestic remedies, respondent state, and victim status. I mentioned to you that in the introductory, the first video, but I thought that it might be useful to repeat it since here it's relevant. So what does happen if an application hits the court? First, the admissibility criteria will be reviewed, in most of the cases by one judge, a single judge, or by a 3-member committee. Now, after that, if the application meets all the admissibility criteria and can go to the next stage, to a decision on the merits, then it's usually, in the majority of cases, it's the 3-member committee or the 7-member chamber, judicial chamber, who are delivering judgments on the merits of the cases. 3-member committee is relevant in cases where it's like an easy case to decide upon, because there is, for example, a recurring problem and issue coming from the same country, and so it doesn't require an in-depth legal analysis to assess whether the state measure or law is in compliance with the European Convention. And all more problematic cases can go to the 7-member chamber. Now, if it's even more complicated, then the 7-member chamber can refer the case to the Grand Chamber. But other than that, the Grand Chamber is an exceptional forum for deciding upon cases. It's not an automatic forum or stage of appeal at the court. And it's up to the court to decide whether she sees that there is a need for a Grand Chamber procedure. When a decision on the merits is delivered by, for example, the 7-member chamber, then both the respondent state and the applicant, the victim of the human rights violations, do have the right to seek for a Grand Chamber procedure. But it's not automatic. So no matter whether the government seeks for it or the applicant, it's not automatic. The court can reject, without any reasoning, can reject that request. So when a judgment is delivered in the merits, then both the government and the applicants have 3 months to decide whether they want to trigger or request a Grand Chamber procedure. When the 3 months is over, then the judgment on the merits enters into force. If one of the parties seeks for a grand chamber procedure, then it's up to the court to decide whether there is such a procedure. Then it might take years, because this grand chamber decision is necessary only in complicated cases, or when the court is expected to rule over its own previous precedents and decisions. So there is a kind of clash and controversy within the case law of the court itself. So this is very briefly and simplistically, these are the rules for the procedures. Now you understand better the chart that is to be seen on one of the slides about the procedure in individual cases. Now let's go further, one step further, to the pilot procedure. You know that this overload of cases and backlog of cases have been a major problem in the operation of the court for years, for ages, for a long time. So basically this pilot procedure was created not a long time ago in order to address this problem. So when from a given country hundreds of cases are coming in related to the same problem, the same human rights violations, then the court would not go one by one with these cases, individual cases, and for years proceed and then come up with individual judgments, but select a couple of cases from a couple of applications from the incoming hundreds of cases, and like 5-6 cases, and assesses those cases in the merits, whether there is really in the given country a systematic and widespread violation of the given human rights. And then if it decides that if it finds that there is such a systematic and widespread human rights violation in similar cases, then it delivers a pilot judgment finding the state responsible for this human rights violation. And then it does not mean that this is a judgment valid only for those 5-6 cases, but it's valid for all similar cases. So basically what happens to all the other applications, hundreds of applications who are already at the court at the moment of the delivery of the pilot judgments? There are two solutions for that. The court can opt for suspending all the other proceedings until the government comes up with a solution for addressing these systematic, widespread violations of human rights. Or the other option is to go on, to continue digesting and proceeding in the other cases. And by that, the court puts additional pressure on the government to speed up the procedure, the process of trying to find an overall solution, a general solution and remedy for these systematic violations of human rights. Now, the government has then the obligation to come up with an action plan within 6 months, and that action plan should be submitted to the Committee of Ministers, which you know is in general responsible for the review, the supervision of the execution of judgments, including the pilot judgments. Now, I give you now a specific example, namely the example of the Hungary and the overcrowdedness of prisons in Hungary, which ended up in a pilot judgment, in order to facilitate the understanding of this whole very particular procedure and judgment type. You see slides from number 27 until 38, so the last slide for this week, and those slides are all about this case. Now I explain a little bit what the slides cover. And this is a good example not only for showing you how the pilot procedure works, but also to show you how an NGO, through strategic litigation, tries to address such systematic problems, human rights problems. So basically, my NGO, the Hungarian Helsinki Committee, detected long time ago, like more than 10 years ago, systematic problems in the detention facilities, the prisons in Hungary, namely overcrowding. And you see statistical data on that on one of the slides. So that's one thing, that the organization collected statistical data, and it was crystal clear that there is overcrowding in the prisons, extreme overcrowdedness. And on the other hand, the organization was getting incoming individual complaints from detainees about physical conditions and overcrowdedness. And plus, the organization was monitoring these prisons and found that there are harsh circumstances, physical circumstances, and really bad hygienic circumstances which should be addressed. So then, of course, the organization was active in researching the roots of the problem in order to be able to articulate potential solutions for the problems. And those examples for those reasons you find on slide number 30. Among them, you find the excessive use of pretrial detention, which means that more than 30% of the detainees were in pretrial detention. Pretrial detention means that they were not convicted felons, convicted criminals, but their criminal proceeding was still ongoing, but there was a reasonable suspicion that they are responsible for that crime, but still there is no judgment yet. So in many of those cases, based on the presumption of innocence, they shouldn't have been in prison. They could have been free while the criminal proceeding was ongoing. So one of the reasons was that largely contributed to the overcrowdedness in prisons. So having all those informations coming from research, from monitoring practices, and from dealing with individual complaints, the organization selected the strongest cases to bring up to the European Court of Human Rights. And those ended up in judgments which found the state responsible for the violation of Article 3 and Article 13. So the violation of the prohibition of torture and inhuman degrading treatments due to the physical conditions in prisons. And on the other hand, the lack of effective legal remedy that would have addressed that human rights violation through, for example, a compensation procedure. So you see in some of those first cases, and where the judgments were delivered back in 2011 and 12, you see extract from one of those cases on one of the slides, which says, where you see that the court declared that there are inadequate living and sanitary conditions in the Hungarian detention facilities, and the authorities should react rapidly. Now, what did happen after that? So we had judgments from the court from 2011 which said that authorities should react rapidly, and then nothing happened. So years passed by and nothing happened with the physical conditions and the overcrowdedness in prisons. And that resulted in a high number of applications appearing at the court. So when the pilot procedure was started up, there were around 400 applications from Hungary and just related to physical conditions in prisons. And so it was clear for the court that a pilot procedure should be started up. So they selected 6 cases, 6 applications from all over the country, from different geographical regions of the country, from different prisons, to check out, examine the really widespread or systematic character of this human rights violation. And the judgment came out in 2015. It's the Varga and others versus Hungary case, where you see on slide 35 extracts from the judgment, and you see recommendations for general measures for the future, for the government to meet, that were like potential tools, suggested as potential tools to create compensatory remedy as well, but also a real solution for the problem. Now, the government came up with an action plan. The first action plan was not too convincing because They were just coming up with the plan of building new prisons, which is clearly not a solution for this problem, because judicial system, there are research showing that the judicial system would again fill in all the newly built prisons, so there would be the same overcrowdedness, just in many more prisons. So it's not a good solution for that, and therefore, because of the first action plan, the court did not suspend any of the ongoing proceedings. So it went on with the proceedings in all of the applications, one by one. But then later on, the government succeeded in coming up with convincing action plans, especially by introducing a special domestic complaint and compensatory procedure. And that was convincing enough for the court. And you see an extract from the judgment delivered in the case of Damian versus Hungary in 2017, where the court is already referring to the fact that this new compensatory and complaint procedure might be seen as being in compliance with the European Convention, and therefore the court terminated all other ongoing proceedings at the court. And so basically all the detainees who were still suffering from physical harshness in the prisons, they could, from that time on, they had the possibility to turn to the domestic courts in this new compensatory procedure. And then we will see what will be the end of the story, because the Committee of Ministers, who is entitled to make the final decision that the case is closed and the execution is completed, and that decision has not been made. So the Committee of Ministers is still today monitoring the Hungarian state, whether this problem was terminated as a whole, since today we still have serious problem with regard to overcrowdedness and physical conditions. And you will find useful information about that and more nuanced information about that for example, on slide number 37, including information indicated in my NGO's communication to the Committee of Ministers. Okay, if you have any questions or comments, feel free to come back to me on the forum. Feel free to interact. I'm available at the time of the course. See you next week.